All right, excellent afternoon to all those who are watching me across the states in Nigeria. They say governance and accountability cannot be divorced in a system that promotes sanity. Likewise, justice cannot be divorced from laws, and hence the reason we, or will I say, hence the reason we, the laws of the land, are the vessels of justice and the decider for accountability. Again, I say welcome to another interesting episode of Real Talk with Kike. I remain your convener, Kike Atanda-Owo, and of course, I think it's important for us to hear what on this day in history segment has for us. Stay with me, I'll be right back. All right, many thanks for staying with me. I think thus far on this day in history segment, I just like the way it's been put in terms of, racist, while minority government to a multi-racist democracy is still, has been emphasized on this day in history segment, especially when it comes to South Africa that has fought for this and they've achieved this. And that is what gave them the boldness and the courage, to take Israel to International Court of Justice on the crime of apartheid and, of course, genocide in this single contest in South Africa, which have led, if you ask me, South Africa have always, led in Africa. And I think that's my takeaway from on this day in history segment thus far. It's time for us to get a message from my sponsors. When I return, we'll go straight to the main conversation. Stay with me. I'll be right back. All right, many thanks for staying with me. The Kogi State High Court in Lokoja on Friday ordered the chairperson of the EFCC, Ola Olukayode, to appear before its court on the 13th of May to show why he should not be jailed for allegedly disobeying its court order. And former Kogi State Governor Yahaya Bello application initiating a contempt in terms of charge against the EFCC chair is a part of the ex-governor's effort to stop his arraignment and trial on 80 billion money laundering charges instituted against him after he left office as governor in January. And former governor Yahaya Bello resists arrest, citing the court's injunction, and EFCC claims lawful pursuits based on separate warrants. Legal clashes highlights power struggles, and of course judicial independence is also what is in play at the moment. And on the live show today, questions surrounding judicial independence, abuse of power, selective justice, and of course the implication for anti-corruption efforts in Nigeria will be analyzed with my guest today. And the key points of contention include the alleged disregard for a court order and the political movement behind the legal actions and the broader implication for trust in governmental institutions and the rule of law. Before we delve into real talk today, it's important for you to let's see the profile of my guest together, and when I return, we'll go straight to the conversation with him. Stay with me, I'll be right back. All right, many thanks for staying with me. Let me use this opportunity to usher in my guest, Barrister Evans Ufeli. I hope I pronounced your last name properly. It's a pleasure to have you on Real Talk with Kike today. How are you doing today?
Very well, good afternoon.
Excellent afternoon to you. So let's just dive straight to the topic at hand, because Nigerians are astonished at the play going on at the moment. The public started with a case of former governor Yahaya Bello, against, or will I say versus, the state on the grounds of alleged corruption to a tune of 80 billion naira. Now, scenario has changed to EFCC denying court order. What should Nigerians be focusing on this matter, really?
Yeah, the case is one that actually boggles the mind. It couldn't have gotten this bad if parties in the case had comported themselves in such, especially the EFCC. You see, Yahaya Bello have refused to submit himself to the EFCC because of the way the EFCC actually went about this case from the outset. Now, when you want to prosecute a man and you choose to start your prosecution with persecution, using the media, harassing him, you only push him. When you do that, you push him to go to court, because according to the law, Section 46, subsection 1 of the 1999 Constitution says that if anybody in the country, any citizen, feels that his rights is being unlikely to be breached, that person have a right to go to the High Court to file for the enforcement of his fundamental rights. That is the foundation. Now, EFCC had acted and behaved and put themselves forth in a way that pushed Yahaya Bello to go to court to enforce his fundamental rights. While that was ongoing, he procured an order of the court to restrain the EFCC from intimidation, from harassment, and from arrests. Okay? Now, that is what any reasonable person would do, because once your right is likely to be breached, that is what you should do. That is one. Now, when that was procured, the EFCC went on appeal to have that order vacated so that they can now properly arrest him. Now, the appeal, the case on appeal was still subsisting when the EFCC now went to his house against court order. Now, going to his house to create a scene, then thereafter called for a press conference and began media trial. Nobody is saying EFCC should not prosecute. Nobody is saying that when there's reasonable suspicion, you should not arrest. Of course, that's what the Constitution says in Section 35. Upon reasonable suspicion, you are supposed to arrest. But, arrest should not become persecution. It should not become intimidation. It should not become order. Because when you do that, and I'm saying this advisedly, so that these people will take a note, because they appear not to know that the way they comport themselves before arrest usually pushes the suspect to go to court and file. Now, back to the issue. The order procured was still subsisting while they went to his house. That is contempt of court, really. And after that, they called a press conference and started, making a case before the press, almost like prosecution before the press. The prosecution is supposed to be done in the law courts and not the press. And they further deepen the illegality against him. Now he has approached the same High Court of Kogi State with, an application for contempt, because the order of that court, the EFCC is in contempt of it. So right now, the EFCC chairman is supposed to make himself available to that court to show cause why he should not be committed to prison.
All right, many thanks.
Meanwhile, EFCC, on the other hand, are still plotting and finding how they are going to arrest the suspect. If there were no court order, fine, you can go ahead. When the suspect refused to come to give himself out when he's invited, by any means, you can actually go to arrest him. That is the law. But where there's a subsisting court order, you have no right whatsoever, not even as an institution, to disobey the orders of the court and then go ahead to carry out the same function that there's a restraining order precluding and preventing you as an institution from doing such.
All right, many thanks for your insights, thus far. And while speaking, two questions come to mind, because first question is former Governor Yahaya Bello justified in accusing the EFCC of contempt? Because you also have mentioned the contempt of court, in terms of, could this be interpreted as a tactic to evade persecution for alleged money laundering? And should the EFCC be held accountable for allegedly defining a court order, or does this pursue of Governor Yahaya Bello on a separate grounds warrant of their action? That's my first question to you. My second question is the fact that, because while you're speaking, yes, EFCC acted in courtesy by inviting the former governor to their organization, Nigerian human rights activists. I know Libero Soshoma also said this, that the EFCC invited Yahaya Bello from the back door in form of plea instead of firm-handedness. Do you share the same opinion with him? I mean, Liberos, who is a lawyer, he has been on this platform to a couple of times. Or you are on the side of the EFCC that it should be treated with courtesy?
Well, let me start from the first question. The first question has to do with the fact whether the EFCC should submit itself to the contempt proceedings. You see, he that comes to equity must come with clean hands. That's a legal maxim under the law. If the EFCC have this vigorous agitation that they want to prosecute Yahaya Bello under the Nigerian law, they must also come under the Nigerian law clean. Okay? Now that there's a proceeding, a contempt proceeding, okay, the EFCC must submit itself to that contempt proceedings, okay, to go to that court and show cause why they should not be committed to prison. It is important that is done, because if that is overstepped and they are now making frantic efforts, concerted effort to see arrest Yahaya Bello, it means that they have come to equity with dirty hands and the laws will not avail them. Okay? Now, on the other side, you talk about the issue of how he was invited. I was invited through the means through which he was invited, whether being courteous to him or inviting him as any other person in the country. Which side do I fall in? Now, my own submission is that the EFCC chairman made a case on air that he called the EFCC, he called Yahaya Bello. He even said he ought not to have done that, but he called him to give him, as an ex-governor, to give him that privilege. But the governor said that there are journalists all over the place. Someone has employed the service of journalists all over the place to embarrass him. And the chairman now went further to say that if that is the case, I can ask them to open the back gate, my own special gate, through which you can come into my office, and I will get my boys to interrogate you on the matter. We have to clear certain issues and all that. And the governor, ex-governor, declined that. So when you look at that, is not very good to the public, because we are supposed to maintain one procedure, one law. And because in this case, it looked like there's a process for the ordinary Nigerian and there's a process for the elite. That is not tidy at all. That is your administrative and logistic issues that ought not to come to the public glare, because that shoots you on the foot when you let the public know that for privileged people, you can have them come in through the back door. People can insinuate anything. Some people can insinuate that possibly you were calling him for settlement and the rest of that. It's not tidy to do so. And I think that was in bad taste. The normal way we know, according to Section 35 of the 1999 Constitution, it says that once there's a reasonable suspicion, that someone has committed an offense or is likely to commit an offense, by his disposition, the police, the relevant authority, have the right under the law to arrest. Section 6 of the Economic and Financial Crime Act, the EFCC Act, also allude to that fact, okay? Nowhere in the law is it that you must send an invitation to writing or through text message or through call. Arrest is what the law says. So the invitation is an administrative duty, okay, of the agency, whichever one suits its purpose, it can deploy. Okay, but what we are talking here is actually that should you go to arrest a man when he has a court order restraining you from doing so? You understand? It's not that the law provides that people should get injunction to prevent law enforcement agency from arresting them. No. People go to get injunction to prevent the law enforcement agencies from abusing their powers under the law. And that's what Yahaya Bello did. Before the arrest, there were a lot of intimidation, there were a lot of movement here and there. Yahaya Bello couldn't have just stood up one day and then go to court. If his rights have not been threatened, if there's no likelihood of threatening sin, you understand? And if there's no imminent danger against his life by virtue of what he has seen or his encounter from the agency. So that is why we say that if you have to arrest, do not make a scene first. Do not create pandemonium all over the place if you want to prosecute someone. Get your evidence, do your investigation, get your evidence, and then don't threaten, don't arrest, go and arrest. Because once you threaten, you push the defendant or the suspect to court to obtain a restraining order against you that his life is threatened. All he needs is to show the court evidence. Once he's able to show the court evidence that he's threatening, is frightening, and all that, the court will grant him an order restraining the agency. And that is what has happened. And I see a lot of people making comments in the public space that they do not really understand the fact of the case. If we make this analysis, the people look at us as if we are supporting the fact that individuals can go to court to get orders to restrain law enforcement agency from acting. No, that is not the case. We are telling the law enforcement agency that they should redeploy and change their logistic procedures when they have to arrest. They do not need to threaten people. Sometimes even when they arrest, the moment they arrest you, they begin to treat you as a convicted person already. Even when your case have not been heard, your statements have not been taken, nothing whatsoever, fair hearing have not been given. They've concluded that because the EFCC are the high-ranking law enforcement agency in Nigeria. If it does not follow procedure, I wonder what other institution in this country will follow procedures.
Many thanks for your elaborate submission right there. Before we go on a quick break, let me ask you this, because this has been in the public space and the body of evidence are out there in the public domain where they seems to be undeniable, so to speak. The school has made the transaction public that state funds were used for personal and children's education by the former state governor. And how is that defendable in the court of law, if I may ask? And was the school wrong to have them public in the first place? As a lawyer, I would like you to come from a legal perspective. And my second question is the fact that, which is still interwoven with the school issues, and because some of the allegations from the camp of Alhaji Yahaya Bello is abuse of power. Did the EFCC abuse its power by attempting to recover funds from American International School, Abuja right now is also what I'm bringing to fore. Because I'm asking, because allegedly, we've been told that, he paid, Alhaji Yahaya Bello paid the children's tuition fee or his family members for, through the coffers of the government. What's your take thus far, before we go on a quick break, with all that is surrounding these allegations?
Let me start with the first question.
Yeah.
When the school refunded that fund, the school did not say it was from the government coffers. That's not what the school said.
Okay.
That fund was, it was refunded on their own volition based on what they are seeing. Okay. Now, EFCC have the power under the law to do what they call tracing. EFCC have the power to do what they call confiscation. EFCC have the power to go to court to seek for interim injunction. You understand? So those are issues under the law. But all these issues mentioned, okay, when you get to court, when the case is fully heard, okay, and evidence are not fully supporting those actions of EFCC, we've seen cases where the court will reverse all those issues, okay? It's left for the court to do so. That is why the EFCC is not given absolute power to recover, confiscate, and all that. It's interim, okay? So anything they do that is done wrongly during trial, when core evidence meets trial, cross-examination, when they go through examination in chief and everything have been concluded, the court will make the necessary orders in its judgment. You understand? So it's not about what the EFCC they are doing now. Anybody can refund money. Anybody can say, you did this, you did that, you did this. Of course, allegations are flying left, right, and center. Now, this whole issue will be now reduced to a block during trial. Then the EFCC 19 count charges, they will have to get evidence to, corroborate, okay, evidence all the charges against the defendant. Any charge that succeeds goes, any of the evidence that succeeds goes in. Anyone that is a challenge and there's an issue, the court will rule on it and all that. So when trial is concluded, then the court will now decide as to what has transpired on the strength of the evidence before the court. So the issues right now are that both sides, everyone is running on allegation. Every side believes they have the right evidence to prosecute this case and to have this case concluded in a way. But the court will have to do what it ought to do. And if any side have done anything wrong, the court will reverse them. That is the procedure of law.
All right, glad to know you're still right there with us. In case you just joined today's show, today's conversation is about the intense clash between the former Kogi governor, Yahaya Bello, and EFCC, and I've delved deep into the allegation of contempt, judicial orders, and of course, power struggles. And my guest on the show, I've been answering questions such as, is Governor Yahaya Bello evading justice or standing up against perceived persecution, or is the EFCC enforcing law, overstepping bounds? And more light has been shed on the ongoing legal tussle. And many thanks Barrister Evans Ufeli, for all that you've shared thus far on this platform in terms of shedding light on the issue at hand. But before we go further, I think it's important for me to open the phone lines. Remember that you can be part of this conversation by calling the studio number 080-988-77400, showing on your screen right now. We're streaming live on Facebook, not on YouTube at the moment, on Real Talk with Kike platform, and of course on Silverbird platform. So, Barrister Evans, with all that you've shared thus far, there's a need for the public's trust to be won by both the legal parties involved in the trial, and of course for there to be a sustained confidence in the mandate of the EFCC in pursuing this obligation. I must ask you, how can a high-profile legal battle like this, particular one, be managed to maintain public trust in anti-corruption agencies and the government overall in terms of commitment to fighting corruption?
Well, every one of us in this country must support the EFCC. That is what I think. We need the EFCC. The EFCC, they are doing a very good job. I will commend them for fighting corruption and doing all within their powers under the law to ensure that the people, this country is safe from criminality and corruption. I mean, we give them that accolade for being that forthright. Okay, but whilst they are going about their duties, they should keep looking at the law. Okay, my analysis or my position is not popular. It's not popular because I'm looking at the law, dispassionately. I do not have any link with whether the EFCC or the suspect. I do not have any link. My own is to state what the law says. One of the way we could promote the rule of law and the EFCC itself as an institution is to ensure that we all follow the process of law. If a man has procured an order, the EFCC, they are very much aware of this. They have lawyers, they have a legal team. You cannot overstep that order to, even when you know that you are going to appeal the same order, which is withdrawn by the way now, you cannot overstep that. That is why they are falling into more problems. That's why the issue of contempt has arisen now. Okay? we are trying to solve one, we are creating a problem for another. We will be able to encourage the fight against corruption and upholding the powers of the law enforcement agencies in our country, where the law enforcement agencies themselves are not reckless, where they abide by the rule of law, where they take the rule of law as the hallmark of their operations. Okay? In this case so far, we've not seen that. Another issue again is the way the EFCC treats their suspects is one other reason why a lot of people do not want to submit themselves to the EFCC. To be fair with them, with due respect to them, the way you get into they invite you to their facility, you go there on your own volition, having been invited as a law-abiding citizen. You get there, they convert an invitation to an arrest. They keep you in their facility and ask you to go and bring 2 shorties that must have houses in Abuja. And you do not know how to get that. And you'll be there as long as possible until you're able to get that. That kind of treatment is already, they're already telling you that, I mean, for showing up alone, they're already treating you as someone who is guilty of the allegations against you. They must change that. They must change that. 3, the way they investigate. Investigation is critical. Prosecution starts from investigation. The way you investigate your case will determine whether you will boldly during trial or not. You understand? Because the law is that once doubt is created in the mind of the court, okay, that case must be resolved in favor of the defendant. So investigation is critical, that the EFCC must investigate appropriately before they make arrests. And when they make arrests, they should make arrests in a manner prescribed by law. They should not start from the press. They should not start from the press, wherein they now push the suspect to go and obtain an order, a protective order of the court for his fundamental rights. In that case, just like in this one, it becomes difficult for the EFCC to move forward because they will be stuck. They'll be stuck in between trying to vacate the order procured by the suspect and trying to solve the issue. Now look at what went on after this whole drama. They file a charge. You file a charge at the courts. After the charge is filed, the case is sub judice, meaning that you have submitted to the jurisdiction of the court. After filing a charge, you go out there and start to organize media conference. You start to organize a press conference, wherein you start to reel out all your evidence, to reel out, to convict the suspect before the press, to appear worthy and working. Before you even get to court that you have submitted, the case is sub judice. So you're already conducting the trial that you took to court outside the court. So when we see some of these things as lawyers, we cannot close our eyes to these things. We can't. Right. We're not saying you should not arrest whoever you think has committed an offense. We are saying that while you do that, you must do that within the confines of the law.
I concur with what you've shared thus far, because as it is now, there's a fraction brewing on this case. Some believe that they are sponsored faction, taking sides in Kogi State. Protests took place at EFCC office, and it comes across to the public like the EFCC is unbalanced, for lack of a better word right now, with their actions or with his actions as they detain some members supporting Yahaya Bello. What's your take thus far with such action? It's in the public domain.
The EFCC had successfully arrested ex-governors, prosecute them and convict them. We have Joshua Dare, we have Wojus Okalo, we have the one from Taraba State. They were all arrested, prosecuted, and convicted before President Buhari granted pardon to them. The EFCC did that single-handedly, without a sin. So let the EFCC go back, because why they're having problem with this one is the procedure they have adopted. EFCC should go back to those old days where they pick a governor and they take the case on. Not too long ago, the ex-governor of Anambra State, Willie Obiano, the day he left office, the next day he was on a flight to the US. He was apprehended. He was arrested. And they took him in, took his statement, did everything within now the case is in court. So that is what to do. That is how to go about it. I don't know why the Bello case now turned out this way. Because when you begin to hang the man and threaten him with your powers, before you start to talk about prosecuting him, he will go to court. He will go to court. And when he gets to court, your case will become difficult for you to prosecute. That's exactly what has happened in this case. You understand? We are out there to state the law, to say what is right, to even assist the EFCC in our own capacity by making these submissions so that they can forestall sin in the future. If they continue this way, they are not going to have convictions because they would have tainted and boggled the case. So people who went to protest at the EFCC office and are protesting for and against, they are doing all this because of the drama created already by the commission, with due respect to them.
All right, many times.
They created the drama, so...
Yeah, many times we are running out of time, so I'm trying to manage time right now. You know, with all that you've shared thus far, I'd like to touch on this because I keep it real on this platform. Some fractions believe that Senator Natasha Ikpoki is also fueling this controversy against Yahaya Bello, you know, in Kogi State. And despite history of rancor between the senator and the former governor, are there facts to support this narrative that is out there?
Well, there's no evidence so far I have seen that Natasha is involved in this. The petition against Yahaya Bello, whoever submitted the petition submitted to the EFCC, that petition is not in the public domain. When we look at the petition and look at the author of the petition, we will now know, okay, this is the person who wrote the petition. So I cannot sit down here and say she's involved in the case or she's the one fueling whatsoever when I do not have the evidence to so say. Okay, so that is why I cannot actually comment on that to say it's involved. But what is important is that there's a petition already, and from the petition they've made a case. And that case, the EFCC had done investigation. But what they have not done proper is what we are discussing today, which has led to the contempt proceedings having violated a court order. They will have to answer to that contempt proceedings. It's very critical because if they don't do that, it will be difficult. This will, truncate or make it difficult for them to proceed. If you are going to prosecute a man under the law, you must also submit yourself to the same law to ensure that you have equilibrium. When you have equilibrium, then you can move forward. But if you are not able to do that, the case will be dragging, going back and forth. We lawyers in society must state what the law is, no matter the law has nothing to do with morality. It's not a popular place to stand in a society where people believe that upon allegations, the person who is so alleged to have committed those offenses actually committed them, even when the court have not said so. But it's only the court that have the rights to say so. And let me let the public know that the fact that the EFCC is wrangling to arrest, and Yahaya Bello is also stating his fundamental right and other, does not mean the EFCC will win the case eventually. It does not also mean that Yahaya Bello will win the case eventually. The case is going to be won or lost on the strength of evidence. On the strength of evidence. So criminal prosecution is evidence-driven. That is what is important. You see this issue of arrest, no arrest, arrest, no. When the case commences, they will become immaterial. The only thing that will matter when the case starts is evidence. And that is what you're talking about, that do not boggle your case even before it starts. Don't ground your case before it starts. That is exactly what we will advise as lawyers in society. We will not see that and shut our eyes will state that for the public to take it or leave it. But that is what the law is. It's not about prosecute, prosecute, prosecute. When you are prosecuting wrongly, you will not get conviction.
Wrongly, you will not get persecuted. But what I want to say right now, and this might be my last two questions to you because of time, we need to move to the last segment of the show, is that should EFCC's previous appeals against contempt charges, stemming from similar dispute with Governor Bello's camp be viewed as a pattern of misconduct? Because with all that I've gathered thus far, or are they legitimate legal maneuvers? That's my first question to you. My second question to you, because of time, is that considering the complexity and the contentious nature of this case, how can the judiciary ensure that they uphold the rule of law while addressing the conflict claims of both parties by the time trial begins? Yes. What's your submission on this?
Okay. Let's first of all look at the first question. It has to do with the appeal that EFCC filed, which I would run now. Where they got it wrong is that after they had appealed the order, restraining them, they went to arrest again, which is a violation of the order, because the order says you should not arrest and you should not intimidate and you should not harass. So they went to do that by creating a scene. So that is where they fell into the hands of Yahaya Bello, for which he has now gone to court to file for contempt. That's the first. The second one is, how will the judiciary uphold the rule of law in determining this case? Of course, the rule of law will be upheld. Our laws are quite straightforward. One of the major principles of law under the case under reference is that he that asserts must prove. That's the Evidence Act. He that asserts must prove. The EFCC, they are making an assertion based on allegation. It is not enough to assert. You assert in one hand, then you prove same. You enhance and corroborate with evidence to show that the adverse party is fully incorporated. If you are not able to do that, and there's doubt with your evidence, your evidence are not strong enough to incorporate the adverse party, then the court will resolve the case in favor of the adverse party. That is what it is. There's no settlement here. If you say that he stole 800 billion or 80 billion or whatever billion you have said, so you must, as a matter of fact, show the court evidence of how the money was moved, from where it was moved and to where it went to. And you must also link the defendant to that crime as a person who moved the money to where it went to establish crime. Right. And your charges must be such that they push to that direction. Without which
unfortunately, I have to interrupt your line of thought. Apologies, we've run out of time, and I need to take the last segment of the show. Many thanks for all your submission thus far on this issue. But before I let you go, let's discuss the trending stories that affect you and I as Nigerians, as Africans. The first trending story that caught my attention is that of the fuel scarcity and the queue crisis. This is where I have an opinion as a host. And let me first of all say this before I come to you, Barrister Evans. There's just so much hardship for the common Nigerian to deal with these days, and this is becoming frustrating if you ask me. It has become like a yearly pattern of we experiencing not less than 4 or 5 times fuel scarcity season in 1 year. We are a developing nation with abundance, if you ask me, yes. And the issue of pricing, logistics, supply, distribution should have been resolved decades ago, And why must Nigerians be subjected to long queues and exorbitant prices of petroleum products? Some unprincipled, for lack of a better word right now, in terms of unprincipled elements, have started selling for almost 1,000 plus per litre. And the fuel is costly. I must put it out there. We all know this. Yeah, we are queuing to buy it. And when Nigerians think that the expensiveness, again, for lack of a better word, should have been cancelled out of the need to queue to buy fuel or gas, queue patterns every time is not funny anymore in this country. I don't find it funny. I understand, my staff are telling me that, they go to banks or companies now, they are switching off lights every now and then in reaction to the fact that NNPCL has responded saying that unfortunately that they are experiencing a 3-day disruption in distribution due to logistics issue, which has since been resolved. And similarly, I just feel that the National Vice President of the Independent Petroleum Marketers Association of Nigeria have expressed hope, if you ask me, when it comes to the queue in Lagos, in Ogun, in Abuja, which he said that it will ease off this week, relying on the words of the NNPCL now, is because I stumbled on this before coming on set. And I think there's been an improvement over the past few terms in terms of communication. I'm a communication student, and I feel that in the last few years we've never seen such effective communication where you see somebody who is in that power communicating quick or swiftly with Nigerians. And now it is a lot different from how it used to be. But another level of improvement also that I felt that I needed to bring to fall in terms of what is expected from the NNPCL and other associated agencies to improve transparency and accountability, which I feel that is the major challenge in this country right now, because NNPCL and PPPRA should have released reliable information on volume of petroleum products in supply, the price regulation, in terms of mechanism, and how to checkmate exploitation in terms of inflation as well in the supply. With that, I just feel that there will be more effectiveness on all fronts, rather than all this pattern of culture that has become a thing for us in this country as well. But quickly, let me move to second trending. And the second trending story that caught my attention also is that of Benin traditional cans that cancelled or suspended 5 of their functionaries, that went out there. But quickly, because of time, because I feel that this news, came as an interesting one to me. Then again, upon reading the official letter of the Secretary of the King of Benin, may his reign be long, I found it as a serious matter, because lessons need to be learned from the Benin monarchy. One, is a no-nonsense monarch, because people think that because it's a monarch tradition, they shouldn't have any rules and regulation, or shouldn't often be used for impunity. So I must emphasize that this is a no-no. They are leaders, and leadership should actually be ruled by example. And secondly is the fact that misinterpretation is an offense and can lead to disrupts, or disputes rather, amongst kings. The unauthorized visit to the Oni of Ife was for what purpose exactly, I'm asking. And the intention could also be costly from both parties, if you ask me. So many a number of times we have seen how disagreement between kings have. But thirdly is the fact that, because of time, I know I'm running out of time, is the fact that the Oba of Benin has also been known from their ancestors to be very firm, like I said earlier, and a disciplined king. They don't take nonsense, and they don't even engage in frivolous, activities that can undermine their honors or his honor. So I'm sorry to say this, a political appointed government servant can't rubbish them. So what happened in Kano, that the Emir was disposed, you cannot see it happening in Benin, and that is why I just feel that things need to be properly managed. The monarchy had existed way before political or politicians, so to speak, from the West that came to tell us about independence and being a republic. So they confronted the states and its affairs, and I'm sure that there's a lot to learn from this and from all those who are in the corridor of power when it comes to the kingship. So for the sake of time, I will just nip this here and just put a wrap to this. On this note, this is where I draw the curtains of the show. I don't know if I can get the opinion of my guest right now, but this is where I wrap the show. Till I come your way on Thursday, remember to catch me live on Inspiration FM tomorrow at 5 p.m. drive time.